Hello again, I'm attorney Robert Flesses for Robinson Lloyd Career Training Institute. This is part 1 of course number 5. In the next 3 videos, we're going to talk about Wisconsin legislative updates that affect you. These are new laws created by our Wisconsin legislature. Let's get started. The first piece of new legislation involves homeowners associations. Now remember, this law doesn't apply to condos. What it does apply to are homeowners associations that regulate subdivisions or residential planned communities. Wisconsin Statute 710.18 is the new law. The entire Wisconsin Statute 710 relates to miscellaneous property provisions. The definition of an association under this statute means an entity that's created to manage or regulate or to enforce covenants and restrictions for a residential planned community, and that consists of members, stockholders, or other owners, substantially all of whom are owners of residential lots that are part of the residential planned community. Association, as I said, does not include a condominium association. Well, the statute creates a simple statutory structure for HOAs to allow resident access to the rules and regulations affecting their property. It applies to those living in or purchasing a property within an HOA. These are some of the provisions in the law. Well, the first section of that statute is regarding covenants and restrictions on properties located within the association. If an association is created to manage or regulate or to enforce covenants and restrictions for a residential planned community, the covenants and restrictions must be recorded with the Register of Deeds in every county in which the residential planned community is located. If the association for a residential planned community maintains an internet site on which information related to the residential planned community is available to the public, the association has to post the covenants and restrictions for the residential planned community on their website. So the statute provides that covenants and restrictions are required to be recorded in the Office of the Register of Deeds and posted on the association's website, if they even have one. Well, when and how does this rule apply? Well, for new associations, if it was created on or after December 14th, 2022, that association has to file a notice no later than 30 days after the association is created. Associations have to file annual public notices with the Department of Financial Institution, that's the DFI, that contains general contact information. Associations must report to the DFI the name and address of the association, along with the name and address of any management company for the association, and anyone who's authorized to respond on behalf of an association. They have to have their name, address, daytime phone number, and email address, and the association's URL, so members can request copies of the covenants and restrictions and other information that's related to the residential planned community. This information is published on the DFI's website. Well, I looked at the DFI's website. Under the tab Consumer Services, it contains a whole section on homeowners associations. You can look at general information, and it offers a search function for HOAs. You can also read facts about HOAs, association fees, and the new statutes and rules. The contact information for the DFI section is also posted. It includes their phone number, email address, mailing, and physical address of the department. You can search an HOA by their name or assigned number and the municipality or county of the planned community. The DFI's website is an excellent resource for you. You can get all sorts of information if you're selling or buying a property in a planned community. This information helps find applicable HOA rules and regulations affecting property use and liability of owners for fees and any penalties. HOAs have to pay a $25 registration fee to the DFI. Well, what are the penalties for failure of the HOA to provide this information to the DFI? Well, failure to file their initial notice or annual renewal notice with DFI prohibits the HOA from charging late fees or other fines for any unpaid assessments or transfer fee for a residential lot until the notice is filed. Notices of meetings must be released at least 48 hours prior by email notice to each owner or sent via USPS or posted on their website if they have a website or any improved area accessible to residential lot owners. A lot owner can submit a request for a payoff statement for any fees owed. The HOA then has 10 business days to deliver payoff information. This will be helpful for title companies to prepare their closing statements, and an HOA may not charge for payoff statements for the first 2-month period after a request, but an HOA can charge $25 for each additional payoff statement. An HOA can only charge $50 to deliver rules and regulations if they're not posted on their website. An HOA can suspend an owner's rights for failure to pay assessments or other amounts owed, but the HOA must provide, remember we talked about this before, written notice that it intends to suspend along with any actions a property owner can take to avoid the suspension. These regulations are keeping HOAs honest and opens the door to easily accessible information pertaining to an HOA. There's also new legislation for 40-year access easements. Well, what is an access easement? It allows people to access or use a piece of property that they don't own to access a public road. There are 3 types of access easements. The first is for land designed for public use that's permanent. This involves sidewalks that are placed on private property or for phone and electric utility poles. The second type of access easement is appertaining to real estate to provide ingress and egress to a public road by way of a private road or driveway. This includes access easements to provide shared driveways, upkeep or maintenance, walking or bike paths, beach access, or allow an adjacent property owner to access land to walk across another's land because there's no other way to cross and get there. Third, there's also access for pedestrian or equestrian access, habitat and resource conservation, airspace restrictions, encroachment accommodation, and other purposes. How do you find if there are any easements that run on a property? Well, a title search will disclose an easement. However, not all easements have been recorded. And there are implied easements. These are easements that have not been written or noted in a legal description and only exist when they're needed. Easements can affect ownership rights and limit use. The only limit created by an easement is that the owner of a property with an easement can't block or hinder the easement holder's right to use it. There are prescriptive easements that grant limited rights to use an easement when there's a necessity, like a landlocked property needing access to a public road. There is also an easement that can be created by adverse possession. You've heard about that, right? Which is also referred to as a negative easement. This is created by a person trespassing over a period of 20 years that's open, notorious, visible, exclusive, hostile, and continuous. There are exceptions to adverse possession. What does the new law do regarding easements? The new law allows recorded private access easements that are recorded after January 1st, 1960 to run in perpetuity. This means forever. Access easements recorded before January 1st, 1960 also run in perpetuity if certain events occur, like re-recording or physical evidence that the easement is being used. Under the former law, you had to have recorded an easement within 40 years of creation or the easement expired and is unenforceable, even if the original agreement states it runs forever. If an easement agreement provides a specific termination date, then the agreement controls. Here's the third new piece of legislation. It relates to foreclosure equity theft. This new piece of legislation is found at Wisconsin Statute 75.36. The definition of foreclosure equity theft means just that. A homeowner whose property is foreclosed upon by the government for non-payment of property taxes formerly lost their equity in the home after the sale because the government kept the owner's equity that the owner had in their home. Does that seem fair? Absolutely not. The 2021 Act 2016 requires counties to pay any net proceeds from any property tax for foreclosure sale to the former owner of the property after costs. Under the previous law, if an owner couldn't pay property taxes, counties could seize the property and sell it to pay the taxes owed. The county then could keep any excess balance unless it was homestead property during the previous 5 years. And the owner had to request payment of the excess money. They wouldn't just automatically return it to you. The new law requires the county treasurer to notify the former owner by registered mail or certified mail to the mailing address on the tax bill that the former owner may be entitled to a share of the proceeds of a future sale. And remember, the county can deduct costs, including record-keeping costs, legal fees, advertising costs, and title insurance costs. The county can even pay broker fees for selling the property. They pay off any mortgage lien on the property and a bunch of other costs that could apply. In Ritter versus Ross, which is a Court of Appeals case, Mr. and Mrs. Ritter lost 38 acres of vacant land in Rock County with a fair market value of about $37,900 because they owed, get this, $84 in back taxes. The county sold the property for $17,000 and kept the difference, which was a $17,000 windfall for the county. Under the Fifth Amendment to the U.S. Constitution, landowners' property rights are protected by what's called the Takings Clause. That right prohibits the taking of private property for public use without just compensation. This provision applies to both personal and real property. You know the difference, right? When government keeps a property owner's equity, that was called an unconstitutional taking. Well, to wrap this up, we talked about the new laws regarding homeowners associations, which doesn't apply to condos, the 40-year access easements, and finally, foreclosure equity theft. Well, that's it for this video. I'll see you in part 2.